You're too kind. Thank you very much. You're too kind, and it's because of your support that we're able to do all these legal actions and file all these briefs and strategies. And we address every issue here in the legal department of AAPS. All the bad things that are happening to medicine, the bad guys are trying to do to medicine, comes to me, and we have countermeasures, counter strategies to address these and push everybody back. Everybody you can think of, every other organization out there is in some way or another an enemy of freedom in medicine. There's only one group that stands up for the private physician, and that's AAPS. So when President-elect Tom Kendall gave his superb talk this morning, which is a talk, by the way, we don't hear very often in New Jersey, do we? I know we got some students from Jersey. I haven't heard that kind of talk from Dr. Kendall very often where I'm from. But that was a terrific speech he gave, and he mentioned in there, along with sister organizations, we stand up for medicine. I was thinking to myself, Tom, who are those sister organizations? Who are they? Could you name some of them? Because there really are not any sister organizations. In fact, I went to a debate over Obamacare at Rutgers University, which is our large state school in New Jersey. I don't know why in New Jersey we don't call it like the University of New Jersey. You know, you have University of Michigan, you have University of Florida, University of California. I mean, we're so embarrassed about our state, we can't even call our state school University of New Jersey. Call it Rutgers. So I went to a debate there, and some of those sister organizations were supposed to be on my side on a panel debating against Obamacare, against an array of liberal organizations arguing in favor of Obamacare. And I got there, and all the organizations in favor of Obamacare were there, and there was nothing but empty chairs on my side, right? Alita was there. She remembers that. I mean, where are our sister organizations? Oh, they had to cancel at the last minute. You know, they couldn't show up. So I was there against all the supporters of Obamacare, and I looked at them, and I said, wow, it's just these people were right out of the 60s. They had the ponytails, and they dressed like people in the 60s, and I was a young boy in the 60s. I remember that. It was a fun decade, right? But, you know, these people were 70 years old, dressing like hippies in the 60s, and they're 70 years old. It looked ridiculous. And I said to them, you know, I said to them, it's not the 60s anymore. You know, the good intentions, it's not enough anymore, right? The songs were popular in the 60s were like, if I had a hammer, you know. Now that worked in the 60s, right? If I had a hammer. Now it's like, well, why don't you get a hammer and get a job and do the work? And I said to him at debate, I said, listen, you know, maybe you'll get this passed. It's unconstitutional. I'll talk about that in a second. I'll talk about these legal things we're doing. But it's not going to work. You know, it's going to fail. And we're seeing that now. Even Democrats are admitting this thing's a train wreck. It's collapsing. And there are people on our side who say, let it collapse. Let it go. Don't delay it. Let it collapse. The thing is falling apart. The big insurance companies are pulling out of these healthcare exchanges. Do you notice that? Aetna, which makes billions of dollars in profits a year. Aetna pays its CEO something like $37 million in annual compensation. They got enough money to do whatever they want. I looked it up. Aetna has more money than the entire government in New Jersey. All right? It's bigger than all of state government. They're pulling out of the healthcare exchange in New Jersey and many other states. They're pulling out of it. This is the jewel of Obamacare that was supposed to enable poor people to get insurance, and the health insurance companies were like, yeah, we'll cooperate on this, we'll cooperate. They're not cooperating. They're pulling out. Meanwhile, the rest of us have to buy this insurance, so it's a gravy train for these insurance companies. We're all forced to, under the individual mandate, to purchase this insurance, so we get tax penalties. So it's like people have to buy Aetna's product, It's not going to get them the medical care they need, and all it's going to do is enrich these executives more. We challenge that. That's in AAPS's lawsuit. We say in our lawsuit that's a taking of property from one set of private citizens, the average American, to give it to another set of private individuals, insurance companies and CEOs. And you're not allowed to take from Peter to give directly to Paul. Taxes are allowed, but you're not allowed to order a transfer directly from one citizen to another. It's prohibited by the Fifth Amendment. That's taking from A to give to B. That's prohibited. And yet that's what Obamacare, Patient Protection and Affordable Care Act does. So that's a violation of the Fifth Amendment. When the Supreme Court upheld Obamacare, they said we uphold as a tax, but it still has to comply with other provisions of the Constitution. They expressly said that. We're not saying it complies with the rest of the Constitution. We're just saying it's a tax. So these legal challenges are still out there, and we have one of them as AAPS. We're also challenging Obamacare under the origination clause. And if you get out your trusty copy of the Constitution, which I know many of us have, there's one there, right? There, look how many people have a copy of the Constitution with them. Well, Harry Reid, unfortunately, did not have a copy of the Constitution with him. And if he had, he would have looked at Article 1, Section 7 of the Constitution, which is on page 5 of this particular printing. And it says, all bills for raising revenue shall originate in the House of Representatives. All bills for raising revenue shall originate in the House of Representatives. Obamacare did not originate in the House of Representatives. It originated in the Senate. And Harry Reid took a tax bill from the House that had come over, stripped out everything in the tax bill, put Obamacare into that, passed it in the Senate, and then sent it back to the House. But Harry Reid didn't look at the details of that tax bill. That tax bill that he used from the House was not a revenue-raising bill. It was a tax credit. It cut taxes. And therefore, that bill that he used from the House to insert Obamacare into did not meet the requirements of Article 1, Section 7 of the Constitution, which is known as the Origination Clause. So the way they passed Obamacare was in violation of the Origination Clause. And that's in our legal challenge, too. We expect our case or one of these other cases that are out there to reach the Supreme Court and give the Supreme Court an opportunity to see if Obamacare, which was upheld as a tax, satisfies other provisions of the Constitution, and we think it does not. And we think by the time it gets there, there may be a lot of Democrats on the court who'd like to end Obamacare as well, because this is increasingly becoming a political liability for the Democrats as it falls apart. Unions are now against Obamacare because of what it's doing to all the union plans. So we have those cases pending. I had the good fortune, I guess you would say, of being a classmate of Obama at Harvard, and I was on the Harvard Law Review with him, which is a small group of people. He was, yes. He was there. I knew him, but he was being groomed then. Looking back on it, he was being groomed to be president then. And we have one of our board members said that he spoke to someone who had come over from the communist Soviet Union, and that person said that back in the early 90s, which that was the time when we were at law school together, he said the communists, the Soviet Union, in the early 90s, they had somebody in mind, that they were grooming to become president of the United States. Well, history didn't work out quite the way the communists expected, did it? And the communists lost control of the Soviet Union. But Obama was very guarded, rarely said anything, wasn't around that much. I mean, the Law Review is a small group of people that's putting out a scholarly journal. It's a place where people are there 24 hours a day. He was rarely there. He didn't write anything of any significance. And yet when it came time to elect the president of the Law Review, which is by popular election of the members, he was elected president of the Law Review. And then the very next day, it was in the New York Times. Something fishy's going on here. He was being groomed. That's the way the left operates. They plan things out long in advance. They have strategy sessions. They're savvy, they're devious, they're clever, and we need to be savvy on our side too. So let's get into some of the legal actions we're doing. And to the young medical students, as you go out there into the world to be practitioners, to be physicians, caregivers, you need to be savvy because there are a lot of enemies of medicine, and increasingly there are a lot of traps. And if you're aware of them, it's not a big deal. So I'm not here to frighten anybody, but you need to know who the enemies are, and you need to anticipate the problems, and if you're prepared, it's no difficulty at all. So let's talk about one of the obstacles that's emerging to the practice of private medicine, and that's maintenance of certification, or MOC. This is a money-making scheme that is increasingly burdening physicians to an intolerable level. Hours and hours of time, taking physicians away from their patients, thousands of dollars, to take exams that have often no relevance to the practice of medicine, to review charts of physicians, to exercise control over independent physicians in a way that no private organization should be doing. The maintenance of certification groups are making hundreds of millions of dollars. They're paying their executives routinely $700,000 annual salaries to run this maintenance of certification. It has no proven benefit, but it has obvious harms to physicians and to patients. Physicians are starting to get kicked off hospital staffs if they don't comply with this maintenance of certification. There are even efforts to link this to licensure, where physicians would not be able to renew their medical license unless they comply with this maintenance of certification, also known as maintenance of licensure. We have sued to stop this. We brought a lawsuit a couple months ago against the ABMS, American Board of Medical Specialties, which is the umbrella group that sits on top of all these specialty boards, and it has 24 agreements with other specialty groups to impose this MOC on physicians and to put up a website that tells you which physicians have complied with maintenance of certification and which ones haven't. So it's linked to a public advertising campaign to make it appear that doctors who do not jump through these hoops, pay these fees, waste their time on all this nonsense, and somehow they're inferior physicians than physicians who do. An attorney, just to put this in perspective, an attorney's obligation to keep up with certification or whatever basically consists of 12 hours of continuing education requirements a year. 12 hours. Which in most states can be taken by turning on your computer and watching something on the internet. Physicians have to do typically 50 hours of continuing education a year. But that's just the start of it. This maintenance of certification adds hundreds of hours on top of that, and fees, and courses you have to take, and trips you have to go to take the tests. And as Jules pointed out, it's often degrading, the testing. It's a way to exert power over physicians. And it's by unaccountable private organizations. There's no transparency. We don't know if they discriminate. We don't know what their numbers are. They're flunking people in increasing percentages. So you go through all this, you spend the money, the time, et cetera, and then you flunk. And then what do? You have to do it all again. And then maybe you flunk again. And it becomes a huge stress point to a doctor's life. Now, I debated this with some proponents of MOC at a medical college in Philadelphia, University of Pennsylvania, and it was pathetic, really, to see people who actually supported this and listened to their arguments there's no evidence that this has any help for patient care. And some of the things I pointed out to the people in the audience, many of whom were medical students, is I said, you know, do you really need this extra stress in your life? Physicians, unfortunately, already have, on average, a shorter lifespan than other professions. Do you need this added aggravation and stress? The average physician only has time enough to spend 7 minutes with each patient. 7 minutes. That's what they say is the average for the average physician. I'll get to other issues that cause that. Do you need this distraction? No, of course not. It's purely a money-making scheme. And it's a violation of antitrust laws. It's a ton of misinformation to try to pretend that someone who's certified is a good doctor and someone who isn't is not. We have medical boards. We have medical boards that are accountable to the political process. We have medical boards that have to comply with due process, that have to treat people equally, that have to respect freedom of speech, and so on. These private organizations are accountable to no one. They should not be dictating who can practice and who cannot at hospitals or in health plans and so on. So as we got through the debate, I mean, the audience was overwhelmingly against this MOC. In fact, polls have been taken that doctors are 90% against MOC. And the people who are in favor of it are people who either profit from it themselves, and there's hundreds of millions of dollars in profit, or they're connected with some of these other medical associations that somehow is deriving some power from this MOC apparatus. So unfortunately, groups like the AMA, they're on the wrong side on this. I mean, somehow they're linked in some way, and it's hard to determine exactly, you know, who's benefiting in which way, how the network is tied in. But lo and behold, when I sued the ABMS, and 6 attorneys showed up on the other side to oppose the lawsuit, the lead attorney on the other side was an attorney who's represented the AMA for decades. He's on the other side defending this MOC and trying to stop the lawsuit and trying to stop our discovery. We're going to get in and get discovery and find out what they have in mind for this, how they've been doing this, how they've been getting this into hospital medical staff requirements and so on. And already I've traced that they paid this ABMS group, which is the umbrella group, paid something like $600,000 to a law firm in Newark, New Jersey. It popped up on their Form 990 form, their IRS Form 990, which discloses what their expenditures are, and I raised that with the court. I say, well, they say they don't practice in New Jersey, they don't do any business in New Jersey, yet here they're paying $600,000 plus to a Newark, New Jersey law firm. What's that for? And by the way, what this Newark, New Jersey law firm does is it has a relationship with hospitals. And they came back and said, oh, no, what that money was for, that was to help us set up MOC in Singapore. They're going worldwide with this. All the more reason we got to stop this. We're exporting our bad stuff to other countries. Okay, well, it's fun in doing the research and the briefing for this case, and it's pending. So this case, I'll give you updates. If you get our email list, you'll get updates of how things are going. As fun as I was doing briefing, researching articles on MOC, and I get into the Nexus database, which is part of the LexisNexis electronic information system, which is used by most attorneys. It's used by tons of reporters, particularly the Nexus database, which has the news articles. So this is what's used by Capitol Hill staffers and everything to search newspaper articles. And I get in there to search articles on MOC, and I get in there and I saw some articles. This is fantastic, these articles. I can't believe other people are speaking out about this. And I read through it, and I'm like, I'm going to use this. This is remarkably clear and insightful about how bad MOC is. And I get to the bottom of it, and it's from the Journal of American Physicians and Surgeons, our own journal. Okay, let me move on to the next topic, and we'll have lots of time for questions at the end. I want to speak about government prosecutions, which is another area we stand up for freedom of medicine, when the government prosecutes doctors. And some of you in the room may think, particularly younger ones, well, if somebody's prosecuted, he must be guilty. Maybe that was true 50 years ago, I don't know, but today, prosecutions by the government is just another way that the government abuses its power in many cases, exerts its control, and destroys lives. And I get into debates with people about, Russia. People complain about how bad it is in Russia, and I say, well, you know what? We have a lot more people in jail in the United States than they have in jail in Russia. Oh, really? I didn't know that. Yeah, people don't know that doctors are getting prison sentences of 20 years in jail. 20 years. I mean, I watch TV and watch some of these crime shows and stuff, and you go into state court and someone's convicted of murder and, prison sentence, something like 15 years, okay, murdered somebody, gets 15 years in jail. Well, they're sentencing doctors in federal court to prison for 20 years in jail. Was not clear he even hurt anybody. He certainly didn't murder anybody. And some of these cases are sting operations, where it's become a sport, where the government will put in undercover agents as patients in doctors' offices to try to get the doctor to do something that sounds illegal on a wiretap. And some of these undercover agents are very good at this and very clever. And as doctors, we need to be aware of this and recognize the setups that people try to put doctors in, and recognize when it's a phony patient rather than a real patient. There was one case I handled where the undercover agents left the wiretap on a little too long. And after they came out of the office, having entrapped the doctor to entice him to say something that sounded suspicious on a wiretap, they walked outside and they were done with their visit and they had a prescription in their hand. They started giving each other high fives that they did such a good job in fooling the doctor and entrapping him. So they were celebrating and it all got picked up on the wiretap. That doctor faced 20 years in jail, and there was one woman who held out on the jury. One holdout. Everybody else in the jury was ready to convict. And just one woman held out and refused to convict. And it's an interesting psychological dynamic that when you get in criminal cases and you get a jury of typically 12 people, if there's a holdout on the jury who refuses to cave in to what the other 11 people want, that holdout is invariably a woman. It's never been explained and nobody talks about it and stuff, but we know as attorneys, when we're picking a jury, if we're looking for a holdout, we know that holdout has to be a woman. It has to be a woman who's going to hold out. That if 11 people go for conviction and it's a man who's like, I'm not sure, let me think about this, let's wait another day, that man will cave eventually, and he will go along with the conviction. So you saw the movie 12 Angry Men, right? Where it's 12 men, and there was initially one holdout, I guess Henry Fonda, right? No, that's not real life. In real life, they do a remake of that movie. That would have to be a woman who's the holdout. Jane Fonda. Okay, no, we don't like it. Okay, so to show you where these government prosecutions are going, and I know some of you may still be skeptical. And by the way, where you get the 20 years is in the pain medication. That's where you get it. It's where a doctor is writing pain relief. And the government's theory will be that it's what the doctor is really doing is dealing drugs, which is a complete lie. It's complete nonsense. But they'll say he's really a drug dealer. They get him convicted, and then they go under the sentencing guidelines for drug dealers. And then they'll say, well, he practiced 10 years and he wrote thousands of prescriptions. Well, so he's equivalent to someone who did 50 pounds of cocaine or something, and that's 20 years in jail. And that's how they do it. And it's a complete fiction. But prosecutors want longer sentences. That's what they think they're hired to do, is get as long sentences as possible. Many of them. I mean, I'm sure they're good prosecutors too. But there's some bad ones, and they get some extremely unjust prison sentences. So if you're doing pain medication, watch out, watch out. I can tell you lots of stories of how doctors were entrapped. One trick that they'll do is the undercover agent will try to hand cash to the doctor. So he'll be in the waiting room or whatever, and in the examining room, and then the undercover agent said, well, I don't have insurance or something. Let me just give you $100 for this right now for this office visit. But he'll do it in a way that it appears that the patient was given $100 in exchange for the prescription. So that's the way he'll do it. But to the doctor, it just appears like the patient's paying for the office visit. So a doctor should never take cash in the examining room. If someone offers you cash, and we believe in cash, we believe in cash practices, but it's best to have that done out at the reception. And if you see a patient who's doing, odd things like that, if a patient asks you to meet in a parking lot, asks you to meet after hours, comes in with a story that is like, would be plausible to a jury, but is just a little too cute. It's like, yeah, I hurt my back because I work for a moving company and I don't have medical records. I don't, I'm from out of town. I work for a moving company, I hurt my back, I need a script. It's like, that's plausible? A jury would believe that? Jury would believe that immediately. But it's a little too cute. It's a little too cute. All right, another doctor who we're convinced he never did anything wrong. He served about 6 years in jail. The way they got him was he had women whom he was writing a few scripts to for after examining him for legitimate reasons, but the women were drug addicts. They were women in their 20s, and they knew each other, and they made up a story among themselves that they were giving him sex in exchange for the prescriptions. And they made up, there were 5 of them, one of them refused to go along. One of them refused to go along with the story. But 4 of them went along with the story. And the reason they went along with the story and made that up about the doctor was because they all got reduced sentences themselves for their own drug activity. So that's why drug addicts are particularly dangerous as patients. When they get in trouble, they try to cut a deal to get off the hook themselves for the trouble they're in that's unrelated to the doctor. And to get a reduced sentence themselves, they make up a story about the doctor. And drug addicts are very good liars, very good liars. And these women made up a sensational sex for prescription story that once they got that in the courtroom, it's like, the average jury, that's all they remember. Juries, sometimes they're paying attention, sometimes they aren't. I'm a big supporter of the jury system. But once that sex for prescriptions got into the case, that's all they remembered. After the case was over, one of the women admitted it was all a lie. She wrote a letter to her boyfriend and said, listen, I know this guy in the newspapers, because then newspapers are all over it, right? If there's sex in it, the newspapers are all over it. So look, you probably saw this article and story about how I gave sex to this doctor for drugs. No, I made all that up. Made that all up so I can get out of my own deal. She wrote that. She admitted that. Went back to the court and said, look, they admitted it was a lie. No new trial. Judge wouldn't give him a new trial. Because as wrong as it is, not only as wrong as it seems, but as wrong as it is, the American legal system, if it's proven that someone's testimony was a lie after the case, you don't get a new trial if you had a right to cross-examine that person during the case. And if the evidence is just what you call cumulative, it won't get you a new trial. So the judge said, well, okay, she admitted she lied, but you argued at the trial she was lying. And you cross-examined her, and you claimed she was lying at trial. The jury didn't believe she was lying. So you've just given me more evidence that she's a liar, but we hashed that out, and the jury believed her at the trial, so I'm not giving you a new trial. Okay, I know you don't understand it. I don't understand it. Okay, it was shocking to me as an attorney. I know you're shaking your head. It doesn't make sense. It doesn't make sense. But the legal system, it's still probably the best in the world, but it's far from perfect. All right, far from perfect. And doctors are often the victim of it. So let me tell you the case we handled recently. The doctor was prosecuted in federal court because the government said he misrepresented the operation he did in his operative notes. that he was not correct in his operative notes afterwards for what he actually did in the operating room. Dr. John Natale went to a jury. The government's theory was he misrepresented what he did in order to get increased Medicare reimbursement, which was absurd. I mean, the numbers weren't there. I mean, again, this is the kind of thing that like a jury, might believe, and that's the way these arguments are tailored in these prosecutions. They're tailored for the jury. They're not tailored for what the real truth is. They're tailored for what a jury might believe. And a jury, he misrepresented, tried to make a few extra bucks. There's a doctor who was doing an enormous amount of surgeries. He wasn't trying to make a few extra bucks by how he described his operative notes. The jury rejected the government's theory that he was doing this to overbill Medicare. However, as often is the case in these prosecutions, there'll be multiple counts. And the jury will often mistakenly say, well, okay, we acquit him of most of them, but we'll find him guilty on one thing here. I mean, there must be something here. So they find him guilty on one count. Well, what happens when you're guilty on one count or 1,000 counts, you get the same sentence. I mean, that's not an acquittal. You can be acquitted on 99% of the charges, but if you're guilty on one thing, it destroys your career as a doctor. It means you can never vote again. It means you're going to jail for the same prison sentence you would have gone to if you'd been convicted on everything. And juries don't understand that. So they did convict him on one count. Well, the count they convicted him on was for mistakes in his operative notes compared to what he did in surgery. So what that stands as a precedent now is that a doctor who misrepresents or makes mistakes in his operative notes about what he did in surgery has committed a federal crime and can go to jail and can be prosecuted for that. So now the government can prosecute doctors for mistakes in their operative notes, even though it didn't affect billing at all. He went to jail for 10 months. We got involved on appeal. We made the argument. The panel on appeal was concerned about this, but they affirmed, as appellate courts typically do, affirmed convictions. It's probably going to go up on petition to the U.S. Supreme Court. We'll see if the Supreme Court takes the case. That's the abuse of government power. So now they're saying if your operative notes have a mistake, we can prosecute you. It's about power. This game is about power. Who's going to have the power? Doctors, the free market, the patients, or is it going to be government? Okay, let me move on to hospitals. Hospitals, just in the last 5 to 10 years, have exerted enormous control over the medical profession. And I'm sure many in this room have encountered this personally or have friends who have encountered this, where hospitals tell doctors what to do, initiate sham peer reviews against doctors, and the doctors who stand up for the patient or stand up for independent medical judgment get thrown out of the hospital, or worse. Hospitals are, in my opinion, because of their unchecked power, have become one of the most dangerous forces in America today, the hospital industry. And politically, they're getting very powerful as well. About a $500 billion industry with no oversight, no checks and balances. The politicians do whatever they want. They win in court almost every time, except for some examples I'll tell you about. And they feel that they can get away with anything. And they do try to get away with anything. Cases that would turn your skin about what hospitals are doing to physicians. One of the cases I handled, the hospital, because they had an exclusive contract with hospitalists, they had an internist on staff who they felt was seeing too many patients on call and taking business that they would have preferred gone to their hospitalists who are under exclusive contract. They summarily suspended this physician on a Friday afternoon, sent him an email, "You're summarily suspended," simply for economic motivation, maybe some racial motivation as well, to try to destroy that doctor, flex their power, and return the flow of those patients to their hospitalist group. Imagine that, getting an email, Friday afternoon, you've been summarily suspended. Now, for some of the young medical students, you may not know the consequences of that. You get summarily suspended by a hospital. That's going to get reported to the National Practitioner Data Bank within 30 days. And that is a data bank that is used by all hospitals and insurance carriers nationwide And if they see that you've been summarily suspended, they're not going to allow you on their staff. They're not going to want to see you around. They're not going to put you on their insurance network. They're going to look at you like you killed somebody. That's what it means to be summarily suspended by a hospital. In that case, at AAPS, we've got experience with these cases. Now, most attorneys, a lot of doctors, they don't know. Wow, I had no idea. Some doctors will quit at that point. Well, fine. Somebody says, I quit. I don't need you. I quit. That's a big mistake, because if you quit during one of these investigations by the hospital, that gets reported, and that's just as bad. And then you can't, whenever you apply to another hospital, they will ask you, and they will check the data bank, whether any of this stuff happens. And when they see that there's this mark on your record, they won't let you on their staff. And then the medical boards get involved. Your medical boards say, wow, you were summarily suspended. We're going to take action against your license. And that's what the hospital expected to happen to this physician, because immediately gets reported to the state medical board, and they're going to do an investigation, and they may yank your license because you were summarily suspended by a hospital. Well, we know at AAPS, we know how this game is played. And we heard about this, and fortunately, the doctor was a member of AAPS, so I heard about it right away. He got that email Friday afternoon. I heard about it Friday afternoon. And I ran into federal court, and I told the judge what was going on. And it's hard to win these cases in court. It's very hard. Right now we're in a situation where hospitals win 99% of these cases in court. Doctors win them maybe 1% of the time. We're going to try to level that playing field. And we're doing it by bringing a lot of these cases. And I went into court. I moved for an emergency restraining order against the hospital, a TRO. And that triggers certain procedures, usually not in the hospital context. Usually it's for something else. But I implemented those procedures, had an emergency hearing within 14 days, and that federal judge slapped an injunction against the hospital, preventing them from reporting anything to the National Practitioner Data Bank about this. So then, as a footnote to that case, I then brought a motion for a preliminary injunction before the judge a little bit later and said, okay, now I want an order reinstating the doctor on staff. And the judge said, well, let's wait till they do their internal peer review, which you have a right to, the internal peer review, and said, let's wait till that. I said, no, I want an injunction right away. You got to be aggressive in these cases. You got to put them on the defensive. I want an injunction right away. She said, no, I'm not going to address that until the hospital gets a chance to do the internal peer review, which internal peer review is an opportunity to get depositions of all the key officers at the hospital. They have to answer questions under oath and stuff. But I wasn't happy with that. Let's wait. I appealed that thing up to the U.S. Court of Appeals for the Third Circuit and said the district court should have acted on my motion for a preliminary injunction. And lo and behold, the appellate court, the federal appellate court, is one level below the Supreme Court. They reversed what the trial judge did and reversed her delay and ordered the trial court to immediately consider the motion for an injunction placing him back on staff. So now I got a good ruling by the U.S. Court of Appeals for the Third Circuit, setting the precedent that federal courts have to act immediately when there's an issue of an unfair action by a hospital and the right of a hospital to be placed back on the staff and not have to wait for the internal peer review. So we got two good precedents out of this case, one to block the data bank and the other to force them to act immediately. Okay, well, the younger physicians look around at your classmates and you'll see there's a lot of pressure to go and work for hospitals. The hospitals are in an expansion phase where they're trying to get everybody as employees. And I encourage you to talk to some of the older physicians in AAPS about the perils of becoming an employee and how you can lose your control that way. And hospitals can be some of the worst employers to find yourself working for. And it's a switch that many physicians soon regret when they go over from being independent and having control over their own practice to where they're an employee of a hospital that's basically profit-driven and starts to tell doctors on staff exactly what to do, and if you don't do it, you're fired. Take a careful look before you go and work in a hospital. Hospitals, there's no transparency. There's nobody watching them. Think of, where's the oversight of a hospital? Everything else in this country, there's some check and balance for the entity that's making the decision. Everybody. If you're in the free market, there's a check and balance of the free market. There's shareholders who are evaluating the performance of the company. There are no shareholders in most hospitals. If you're in public schools, there's the oversight of the elected public school board. You know, the school board has oversight over the public school. There's certain legal protections too because it's a governmental entity. You're a private nonprofit hospital. There are no protections. There's no oversight. There's no transparency. They can do whatever they want, and they do whatever they want. And go and look on GuideStar.com, the Form 990s of private hospitals, GuideStar.com or GuideStar.org, either one, and look up private hospitals, and you will see, as in this case I just described, where an administrator pulled out an extra, like $500,000 for himself in 1 year, a raise of $500,000 as he was doing things behind the scenes. And look at how some of these administrators at these private nonprofit hospitals are making $3 million a year, $5 million a year. There's no check on that. There's no check on their power. And that breeds a certain type of attitude, a certain type of contempt for any physician who gets in their way. Okay, let me, before I open up for questions, let me talk briefly about insurance companies. Insurance companies are another threat, obviously, to the practice of medicine. And what I encourage the young physicians and all physicians in this room is to consider getting out of insurance networks, going out of network. And at least in New Jersey and in many other states, I'm not sure this is true about every state, but if you're out of network, insurance company, you set your own fees. And if it's an emergency thing in the hospital that you have to take care of, you set your own fee for that. And the insurance company is supposed to pay your out-of-network fee. You don't have to comply with the insurance company's fee schedule. You don't have to comply with all their rules, their oversights, their audits, their harassment, et cetera, et cetera. You're out of network, you don't have a contract with them. You have that independence, and in New Jersey at least, out-of-network doctors feel that they are better off by being out of network and setting their own fees, even for hospital-based work, than going in-network. If you go in-network with an insurance company and you sign up for their plan, you are bound to whatever you sign. And it is pages and pages of power for the insurance company and restrictions on your practice. The insurance company can audit you at any time. They can do all sorts of things to you, and get this, they can even kick you out of their network, which may sound okay at first, but that's reportable to the National Practitioner Data Bank. So you go in network with an insurance company, they decide they don't like you, they kick you out, they then report you to the National Practitioner Data Bank to try to destroy your career. If you're out of network, they can't do any of that. They don't have any power over you if you're out of network. So I encourage you to consider that. Once you go in network, I've heard stories it's hard to get out of network. And some physicians will say, well, they can't get out of network. I don't think it's that hard. You know, you just walk away. They say, well, the contract doesn't allow me to just walk away. Well, you know, one of the first things you learn in law school is that contracts can be broken, all right? You have a right to break a contract. That's one of the first things that surprises first-year law students. It surprised me. It's like you sign a contract, that means either you promise to do what the contract requires, or you break the contract and you're liable for whatever damages are going to be imposed against you in court. Well, if you break an insurance contract and leave the network, what are the damages to the insurance company? I don't think it has any damages. I don't see any damages offhand. I've never heard of anybody being sued for leaving a insurance network. So if you're in network, you want to get out, consider getting out, even if that means breaking the contract. Give that consideration. There's nothing illegal about breaking a contract, a private contract between you and an insurance company. I know insurance companies like to pretend they're the government, They're just a private entity, just like any of us in this room. I know they like to call people up and intimidate them and pretend that they're, they have the power of the U.S. government. It reminds me of the joke that was on TV was like Laugh-In, right? That goes way back, all right? The medical students aren't going to remember Laugh-In, but some of you in this room remember Laugh-In. And Lily Tomlin, right, pretended she was an operator for the phone company, and then one person got on the line and complained to her. They said, to Lily Tomlin, they said, you can't do that. That's against federal law. She said, no, we're the phone company. We're above federal law. We have to comply with federal law. That's the way insurance companies act, but they're not above the law. So know your rights and consider being out of network with the insurance companies. Okay, one final comment before I throw it out for questioning. I looked again at the story of David and Goliath. We all know the familiar story, right? It's funny, though, when you go back and you look at some of these stories, or you look at the Bible, and something jumps out at you that even though you thought you knew the story, and wow, I knew the story, I've heard it 1,000 times, but I didn't remember this part of the story. And David went up against Goliath without a sword. David didn't have a sword. I forgot that part of the story. It's like, okay, Goliath is 7'7", complete barbarian who's destroyed every competitor, and David's a boy, really. But David didn't even have a sword, and David defeated him. And if David can do that in defeating Goliath without even a sword, at the end of the story, the gruesome end, David took Goliath's sword and used it against him. And we can certainly, at AAPS, we can certainly achieve the goals and defend the practice of medicine. Thank you very much.
We have time for questions.
Yes.
And, thank you, Andy. We do have time for questions. I also want to mention that a lot of our effectiveness, in AAPS is exerted through the legal actions that we take. And if you want to do something to help, what I would recommend is that you donate to our American Health Legal Foundation. It's a tax-deductible donation, and we do fund a lot of the lawsuits that we do through that foundation. So, time for questions.
Hi, I have the first question. My question is, do judges hold grudges? So when you told that story about going over the judge's head to get the injunction so that they'd let the guy practice, but then that judge overruled the lower judge, but that's the same judge that's still hearing the whole case. Would that work against the doctor?
That's an excellent question. I would say judges do have memories, but you can also earn the respect of a judge. And when you go over the top of a judge and get that judge reversed, and then you go back to that judge, the judge may not be your best friend, but the judge does respect you and knows that you may do it again.
Okay, thanks.
Excuse me. With regards to the constitutionality of the Obama bill, have you guys also looked at under Article 1, Section 9, third paragraph, no bill of attainder or ex post facto law shall be passed? That, I think, covers that quite a bit. Then you also look at the 14th Amendment, all laws should be equal and fair. That would be under Section 1, Article 14, and also under Amendment 14, I'm sorry, not Article. Amendment 14, servitude. They're basically turning us into slaves.
Yes.
I mean, all of these things are highly unconstitutional. And I think those need to be included.
Yes, those are excellent points. And we are bringing another Obamacare lawsuit to show you how swiftly AAPS can act, like David against Goliath. We had our board meeting yesterday, and we're going to have another one on Saturday after this convention's over, which you all are welcome to attend. We had one yesterday. One of our board members suggested, out of the blue, we should bring a new lawsuit against Obamacare to challenge how Obama is changing the law as he goes along and making it up and not complying with it. The board, if this had been the AMA, it'd be okay, study committee, House of Delegates, we'll consider, we'll get to in a couple of years. Board discussed it, voted unanimously to approve it, and it was on the Hannity show last night.
Hi, Andy. Two points that you made about big insurance that I wanted to kind of elaborate on. More and more, the big insurance companies, United, Blue Cross, et cetera, are putting in their plan documents that for out-of-network, they'll only pay like 140% of Medicare. However, under ERISA law, that allows the physician who's out-of-network to balance bill, okay? Because you have the right, if you're out-of-network, to bill whatever you want. So even though the insurance company might only pay 140%, if you bill higher than that, you can recover. And this goes back to the Blue Cross hidden fees case in Michigan.
Yes. And on that point, if you balance bill, the insurance company goes bananas.
Oh, yeah.
They go bananas. They'll run in and say, no, don't do that. Don't do that. We can work this out.
Yeah, exactly. And then they'll eventually cough up more money. So I just want to add that. The other point that you talked about, companies opting out of the exchange, this is just my theory, and I've had it for a while. But here's what I think. I think that they're in collusion in the smoke-filled rooms that Charlie talks about, and they're starting to divvy up the territory like the utilities, where Aetna's saying, we'll take the Northeast, and UHC is saying we'll take the Southeast, so that BUCA, Blue Cross, United, Cigna, Aetna, Humana, are positioning themselves to take 5 territories so that when we go to single payer, they'll have their set territories. It's just, my tinfoil hat theory, but there you go.
That's interesting. They may be doing exactly that. Go ahead.
Hi, I'm Ray Eisenberg, one of the medical students from Rowan SOM. And just in regards to the hospital, you said they have no real oversight.
Right.
Is there anything like in action right now? Is there anyone kind of trying to take steps to put restrictions on them?
We're doing it in the courts. I mean, we're bringing these legal actions to try to get oversight by the courts and hold hospitals accountable that way. Politicians, they're nowhere to be found. Politicians are afraid of hospitals. Hospitals tell politicians what to do. So I don't see any legislative reform on the horizon, but legally, we're pushing these cases in the courts.
Okay. Thank you.
Did you have your hand?
In regards to maintenance of certification, I find it ironic that when I recertified in dermatology in 2009, voluntarily, and got the list of those who had passed that certification, I think half the program chairmen in the country were on that list of having passed it. And that was the last year that it was open book. So they knew that if they had to take it closed book, they could never pass it.
Yeah.
And I think it's the academics that are driving this whole maintenance certification as well.
Yes, I think that's exactly right.
Hi, I'm Ryan Cole. I'm a triple-boarded pathologist. I have a two-part question. One, is it worth going directly to suing individual boards instead of the ABMS? And two, do you think it a worthy venture to form one's own board instead of the American Board of Pathology forming the Board of American Pathologists and make it a reasonable organization? I mean, it was founded in 1937, and it's an old crony organization, and it's all about money. And instead of competency and practice for the patient. So I've had the thought for the last 5 or 10 years, why not form my own board and then find the people that are reasonable physicians in it to take care of patients, not cronyism. So that's the second part of the question, but the first part is it worth suing individual boards instead of a blanket ABMS lawsuit?
It might be worth suing individual boards, and there have been some lawsuits out there against individual boards. I don't think they've been well constructed as ours is. In terms of forming a new board, AAPS's position is that these boards are a waste of people's time, and we don't want to add to that. We feel a physician's time is best spent with the patient. As I told the court, every hour that a physician is spending on this MOC nonsense is an hour away from the patient. And there's a shortage of physicians in this country.
Hi, I'm Carl Stecher. I'm a neurosurgeon here who did face a summary suspension, but I wanted to think of a bit of irony at first. Can you imagine if they redid the movie and the one female holdout was Jane Fonda? In any event, after 18 years of training, 27 years of practice. I got one of those summary suspensions, and it was in retaliation to what I had reported about the hospital with bad care and so on.
Right.
I was suspended. They throw you out on the curb. This is to let you know, but I wanted to add an arrow to your quiver. They throw you on the curb, and then 6 months later, I had a hearing in front of the HCA Columbia Group, which owns 17 hospitals here in the Denver area. And they said, reinstate Dr. Stecher immediately with no restrictions. They didn't know what to do. They never lost before. They kept it alive with the board, which took my license, and the board said, well, you haven't been tried by us yet either. It's not double jeopardy. So
Yeah.
that's amazingly getting through the hospital board, because you have no rights, no honesty, and they hide everything and they
Yep.
cheat.
Last question.
Jim Story, neurosurgeon from San Antonio. I wonder, I'd love to hear you comment a bit further on the power or lack of power or fortitude of the hospital staff with regard to the hospital administration.
Hospital staff is terrified of a few powerful people in hospital administrations that run the show. And a peer review that I just went through with, that hospital staff lied left and right against the doctor because they were terrified that the higher-ups in the hospital would fire them if they said anything favorable to the doctor. So what you got in these hospitals are a few unaccountable people who are running the ship for their own enrichment. And there's a lot of injustice that happens to doctors as a result. Thank you very much.